Hello, my name is Elena Pop. I'm the Executive Director of the Eviction Defense Network, also known as EDN or EDN. You are here because you have a notice from your landlord and you want to know what to do and what's going to happen. Watch this video and you will get answers to your questions. Follow our instructions and you'll get great results and avoid horrible consequences. But first, some introductions. We're a nonprofit legal services program in Los Angeles County that's been at the forefront of stopping displacement and gentrification since 2003. Use this video with our webinars and empowerment classes. It does not replace legal advice or an assessment of your case by a lawyer, but it will make you a badass eviction litigant. Remember that laws change and the most up-to-date information is on our website and at our Zoom events.
Hello, my name is Mark. I'm a successful participant of the EDN Tenant Empowerment Program. The Eviction Defense Network is a proud member of the LA County Right to Counsel Coalition and its Stay Housed LA program.
If you have a disability, including a learning disability, and need a reasonable accommodation, please let us know.
We cannot have social justice without language justice. Please help us by being patient with the interpretation. Unless we are interpreting simultaneously, speak one sentence at a time. Wait for the interpretation.
We know you're stressed. Overcome your stress through knowledge and power. Watch the videos. Come to the webinars to learn the law. Come to our empowerment classes to learn the procedure and how to be a winner. Come to the tenant support group to get love and understanding and to be around people that have gone through what you're going through and were victorious.
We've developed a video series that gives you all the information you need. The videos are in 3 categories: how to get legal help, mastering the eviction process, and knowing the law.
You are here. How to respond to a notice from the owner. Start by reading the notice and understanding what the owner is accusing you of and how they want you to fix it. And keep listening and watching.
Watch these 2 videos before coming to an empowerment class.
Watch From Zoom to Victory before every class. If you can't name yourself correctly or write a good PIP, we will ask you to watch From Zoom to Victory in a breakout room and to work with a volunteer so that you can write a good PIP. This will delay your participation in the empowerment class and counseling. And by the way, if you don't know what a PIP is, you haven't seen From Zoom to Victory. Please watch it.
Our website is your best friend. It understands your plight. It's available 24/7. It never gets tired nor impatient. It has all the information you need to succeed. Your first step is to watch 3 videos. Number 1, how to get help from EDN. Number 2, From Zoom to Victory. And number 3, how to respond to a notice from your owner. Your questions will be answered there. Come to an empowerment class to ask more questions and to have your case assessed. After watching this video, go on our website at edn.la and get to know us.
You're watching this video because you have a notice from your landlord that says that you have to move out. If the notice is verbal, ask your landlord to put their request in writing. If you're being harassed, watch our video on harassment. Before actually answering your questions about how to respond to the notice, let me explain the eviction process. The eviction process starts with a notice. The notice does not need a signature and will not have a stamp. Notices are usually pulled off the internet. A notice can be totally handwritten. For the most part, they look very informal, and tenants sometimes think they don't need to pay attention to them because they look so informal. If a notice has the right words, it can be what we call the basis or reason for filing an eviction lawsuit. An eviction lawsuit is also known as an unlawful detainer. An eviction lawsuit is called an unlawful detainer because after the notice ends, the lawyers call that after the notice expires, you are no longer a tenant. You live there. You cannot be locked out without a court order, but the law sees you as someone that is unlawfully or illegally detaining or holding on to the owner's property. After the notice expires, the only thing that the owner can legally do is file an eviction lawsuit. If the owner is threatening to lock you out illegally, watch our video on how to stop landlord harassment. Keep proof with you at all times that you're a tenant. Your lease, rent receipts, utility bills. If the owner tries to lock you out, or if he actually locks you out, you call the police and then call our emergency lockout hotline, 213-340-4714. I'll repeat the number, 213-340-4714.
After the owner files the eviction lawsuit, they will give you a packet that has to be answered in 5 working days. Lawyers call this serving the packet. Service has to happen in person. The packet can only be left at the door and then mailed with a court order.
If you don't answer the packet, you will lose automatically, and the sheriff will lock you out. Remember, legal papers can only hurt you if you ignore them or if you get a paper cut.
Eviction lawsuits are very narrow boxes. In an eviction lawsuit, the judge decides who gets to keep possession of the unit. Unit is the word lawyers use for your apartment or home. Do you get to keep living there, or do you have to move out? If you have very bad conditions, sometimes the judge will decide if you get to pay a lower rent until the repairs are made. Many tenants want to get justice for harassment and mistreatment and other violations by the landlord. This cannot happen in the eviction lawsuit. You will have to file a separate lawsuit. If you answer the summons and complaint,
after a long process,
you could win and get to stay.
Or you could lose and the sheriff will lock you out.
Or you will make an agreement in which you get to stay. Or you will make an agreement to move out, giving you enough time to find a new place and a clean record. 98% of the time, we get all the back rent forgiven, and sometimes we can get relocation assistance. How good the agreement is, how much time to move, how much money you get, depends on what we call the 16 factors, which we will talk about later.
How good the agreement is also depends on how prepared you are. You're blessed to have found us early in the process. We can help you get ready.
But what you really want to know is exactly how do I respond to the notice from the landlord?
We are here in the eviction process.
These are sample notices. The first one is a 60-day notice to move out. Sometimes the notice will say move or move out. Sometimes it will say quit. Sometimes it will say vacate. Sometimes terminate tenancy. Sometimes eviction notice. It all means the same thing. Get out, move out.
This is a 30-day eviction notice. It could say move, quit, vacate, terminate tenancy. It all means the same thing. Get out, move out.
Here is a 3-day notice to quit. These are given when they are accusing you of a nuisance, usually something super serious that can't be fixed. Again, it could say move out, move, vacate, terminate tenancy. It all means the same thing. Get out.
Here's a 3-day notice to pay rent or quit. Like all the others, they could have used the words move, move out, vacate, terminate tenancy, eviction notice.
On the screen are other samples. The point of this slide is not to read and understand these notices. It is to understand that there are hundreds, if not thousands, of different types. Each of these notices has a number of days in which you have to do something. The number of days ranges from 3 to 120, depending on the reason for the eviction. If you do not do what the notice says in the number of days that the notice is giving you, legally, the only thing the owner can do is file an eviction lawsuit. They cannot just lock you out. It would be illegal to lock you out. If the landlord is threatening to lock you out, please watch our How to Stop Landlord Harassment video. Always carry proof that you are a tenant with you. If they actually lock you out, call the police. Then call our emergency lockout hotline at 213-340-4714. Again, 213-340-4714.
And you're still wondering what you should do about the notice, and now we're going to tell you. If the notice is in the alternative, meaning it gives you a choice of fixing a problem or getting out, your first option is to do what the notice asks. This is what the lawyers call comply with the notice. If a lawyer says you should just comply with the notice, it means do what the notice says, fix the problem, pay the rent, make sure you can prove that you did. See our video on how to pay rent like a pro. Get rid of the dog, send proof to the owner. See our video on cure or quit notices. Get rid of the clutter, document it, send proof to the owner. Fix whatever the notice says you're doing wrong and send proof to the owner. Sometimes this is impossible. You don't have the rent. Sometimes you don't have to comply because, for example, they're asking you to get rid of your dog, you're in a rent stabilized unit, and the dog's always been there, or it's an emotional support animal. Sometimes you need more time. If you're disabled, you can ask for a reasonable accommodation for your disability. Or maybe you can negotiate more time. Make sure that if you negotiate more time, you get it in writing. Find the video for your type of notice for more details.
Your second option is to move out.
And your third option is to get ready to fight the eviction lawsuit.
If you choose to move out, you must be able to prove that you moved out, and you must check the court regularly to make sure an eviction hasn't been filed, even though you moved out. It is not unusual for people to come to us with a 10-year-old judgment for $2,000 that has now grown to $15,000 because of interest and collection fees. These people did not know about the judgment because they moved out and were never served. A judgment was entered against them because they did not respond to the complaint. Get a written agreement to forgive any rent that you may owe before you move out. Being in the unit, or what we call having possession of the unit, is leverage to get the rent forgiven. We are building a library of videos, including one for each type of notice. Please check our website at edn.la to find a video for your type of notice.
Do not write a letter or send an email trying to defend yourself. Unless you're an experienced housing lawyer, not any kind of lawyer, but an experienced housing lawyer, there are likely to be mistakes. You're likely to say something you should not say. Anything you say in the letter could be used against you, and we don't have time to review letters right now.
Notices from the landlord often have defects or errors. The lawyers will say that is a defective notice. If a notice has a defect, it is not valid. It will not support a lawsuit for eviction. When a notice has a defect or error, there's a temptation to tell the owner, your notice has a defect. Don't do that. If you tell the owner about the error, the owner will fix the error, give you a new notice, and now you'll have to go to court with a weaker case. You should get specific legal advice before deciding what to do. And when in doubt, don't say anything to the owner about the error. Instead of explaining to the owner how they can fix the problems with their case, do the following.
Number 1, get informed delivery at the post office. After the notice expires, the only thing the landlord can do legally is file an eviction lawsuit. Sometimes landlords hide the paperwork from the tenant and the tenant loses automatically. The court will warn you an eviction has been filed. They will send at least 2 warning letters. Tenants often say they did not get these letters. Truth is, sometimes I find it among their papers, still sealed, because they never opened it. So please open your mail. But if you sign up for informed delivery at the post office, you're going to get an email about each letter that you should be expecting in your mailbox. If you get an email and no letter comes, then you can go look for it. You can come here and ask us, or you can go to the court, or you can call the law firm and let them know, hey, an envelope from your firm was supposed to come. I didn't get it. Please resend it. Be on the lookout for letters from the court and from law offices and save all of the envelopes, and please, please, please open all your mail.
Number 2, go to the court every 5 days after the notice ends, or as lawyers say, after the notice expires, to make sure nothing has been filed. Give the address and names of all the adults in the unit. Give the names of all the children too. While it is not correct to sue a child, tricky landlords will sue the children.
Number 3, buy a spiral notebook and log everything about your eviction and about your conflict with the landlord in that journal. Include the date, the time, who was there, their contact information, what agency they're from, and any details. In this example, on December 12th, 2022, at 8:30 a.m., the landlord came with a 3-day notice to cure or quit. And the person is writing, he says that I have extra people and I don't. I think he thinks that because I asked my cousin Marie to be there last week. You notice she puts in the date that cousin Marie was there to be there when the workers came to fix the problem. I tried to explain to him, but he's not listening to me. His son was here and told me that they were going to get me out no matter what because I'm paying too little rent. I asked for help at stayhousedela.org. They assigned me to the Eviction Defense Network, but no one's called me yet. Then 2 days later, at 11:56, she writes, I got an email from the Eviction Defense Network. They're inviting me to a class on Zoom. I don't have Zoom. I called them and they told me to get Zoom. They say it's free. I'm not sure how to do that. So they told me I could come to their office and they will help me put it on my phone. I called my son. He said he would do it. They also said I could watch 3 videos on their website. The videos were really good. They explained everything to me, how to get help, how to work on Zoom, what to do about the notice. I see that there's a video on harassment on the list, so I'm going to watch that next. These classes on Zoom seem really interesting.
Number 4, start putting your evidence together. This might seem like it's overkill for a little notice. Trust us, it isn't. First, you should have all your papers about your tenancy organized. Second, in a month or two, when you are in eviction court, you'll be glad you did this. Get a notebook and dividers numbered 101 to 125. Organize all your papers into categories on this sheet. Do not change the categories. If some of your papers don't fit under these categories, add categories starting at 114. Watch our video on the perfect exhibit notebook and the trial notebook.
Number 5, become an expert on the EDN.LA website. Watch all the videos on the website. Come to our empowerment classes on Monday and Wednesday at 5:30 p.m., Saturday at 8:30 a.m. Come to our webinars on the law on Tuesdays at 6 p.m. in Spanish, Thursday at 5 p.m. in English, and Saturday at 1 p.m. bilingual. Come to our tenant support group on Fridays at 6 p.m., also bilingual. And remember, our system at EDN will send you automatic emails. If you respond to us, we may not be able to respond to you. So you have to come to a Monday or a Wednesday to check on the status of your case if we haven't responded.
Number 6, start to think about how you want this to end. We have a separate video on negotiation and the 16 factors to consider in deciding whether you should fight to stay or agree to move out. We also have several videos called the 16 factors in action. In those videos, we use the 16 factors in real cases. At the empowerment classes, We help you decide whether you should fight to stay or move out. When you come to us, we ask you to pick a path. On the left is the fight to stay path. On the right is the move out path. If you're on the move out path, you should ask for the following. Give me enough time to find a new place. Number 2, forgive the rent I owe so that I can make a fresh start. Number 3, keep my record clean, meaning sealed, so no one will know about the eviction. And 4, give me relocation assistance. Choose a path. If you are on the move-out path, you should figure out how much time you need to find a place to live and pack. How much money do you need for relocation? Keep in mind, your settlement position must be reasonable. If you hang the meat too high, the dog won't jump. If you are on the stay path and you don't have all the rent, you have to decide how much you can pay now and how much you can pay each month. What is reasonable depends on how strong your case is.
To decide your path, think about these 16 factors. Factor 1, the value of the unit. Is it cheaper than apartments like it in your neighborhood? Fight to stay.
Factor 2, is it protected? Does it have what people usually call rent control, but is really rent stabilization? If yes, fight to stay.
Factors 3 through 7. Can we win? If we can, fight to stay. We will do a much more detailed analysis in the negotiation video.
Factor 8. Do you have other leverage, meaning other ways to force the landlord to let you stay and stop harassing you? Fight to stay.
Factor 9. What's your financial situation? Do you look like tenant A, B, or C? Again, our negotiation video explains in detail how your financial situation affects your settlement position.
Factor 10. If you have Section 8, will losing the case mean losing your voucher? Settle. Do you have a job that you will lose if your boss finds out that you have an eviction on your record? Think about early settlement. If you are going to move, talk to us first.
Factors 11 through 16 are the players. We'll discuss the other players in the negotiation video. Today, let's focus on you. Conflict feels bad anywhere. Conflict about your home and in your home with your landlord feels horrible. Most of you would rather not be here.
You would like to escape or give up, or maybe even evade responsibility for your part in the conflict. Unfortunately, in this very expensive housing market, owners often want tenants out so they can raise the rent. And tenants are often forced to fight to stay because they can't find less expensive housing. If that is your situation, then you need to get ready for that fight. That could mean making a deal, reaching a compromise, or it could mean, and often does mean, gearing up for a court battle.
So going back to you, are you ready for that court battle? Are you confident, educated, trained, knowledgeable? Are you ready for that battle? We can help you be all of that and get ready. We can help you become super strong so you can win this conflict. Join our tenant empowerment program.
Every time something changes in the case, we have to ask ourselves, can we still win? This is early in the process. Look at the notice. If you can do something to correct a problem, do it. And take photos and videos and have witnesses and send the photos and videos to the owner.
So now going back to what you can do to respond to the notice. Number 7, start learning to be an expert negotiator. Negotiation is a combination of playing poker, chicken, and let's make a deal. Prepare by watching poker tournaments on TV and by watching episodes of Let's Make a Deal. And watch the original Point Break movie with Patrick Swayze and Keanu Reeves. It features a classic negotiation in midair. Pull the card, Brody. No, you pull it.
Number 8, work on your poker face.
Number 9, look for housing. Look for housing even if you're fighting to stay. It'll give you options. Clients that are not making an effort to defend themselves really wake up when they realize how hard it'll be to find new housing. And if you lose, you may be eligible for a hardship motion. It's stronger if you have a long history of trying to find housing. So let us know if you find something so that we can try to negotiate a move out. But don't tell your owner first. Let us know first at the Monday or Wednesday empowerment class.
Number 10, save your rent and apply for rental assistance. Remember, you owe all the rent for all the time you are living there. Even if the landlord has rejected your rent, you still owe it. You need a plan for paying any rent not covered by rental assistance. You need a plan for paying future rent once the COVID protections end. If you were COVID impacted and can prove it, you can't be evicted for any rent that came due while there were state or local protections for your unit. But you owe it. We need a plan for getting it forgiven or paid. If you are being bought out, you are negotiating good money to move out of what the lawyers call a substantially below rate market unit, which is a house or apartment that is way less expensive than other places like it in your neighborhood. Let us connect you with a nonprofit organization that helps non-traditional homebuyers. Contact Erica Torres at Haven Services. This is a HUD-approved nonprofit agency that helps non-traditional homebuyers.
Number 11, learn to testify starting today. Keep the following in mind whenever you're talking about the case, and especially at the empowerment classes and webinars.
Keep calm and watch your tone.
Well, we learned in the movie Inside Out that all of our emotions are useful and have to be respected.
You cannot make decisions about your housing from a place of fear.
And you must have your emotions in control when you're talking about the situation, and especially when you're testifying. We know you're fearful and anxious and either angry or disgusted with the situation, and you have every reason to be. But because of those emotions, tenants tend to talk about their situations in an angry tone. They practically yell at us as they're telling their story, or in a whiny tone that makes the listener want to run away rather than listen and help, or in an indignant tone. And then they did this and then they did that. These are not winning tones.
Learn to use what we call your late night FM DJ voice. Deep, soft, slow, and reassuring.
As time passes, the facts will get fuzzy. Now is the time to remember. In your journal, make a timeline of your tenancy. Remember dates, look at old photographs, journals, and appointment books to remind you of dates. Never guess at dates. If it's about an incident, go to the place or picture the scene, the objects, the area, the distances, and exactly what happened.
Listen to the question.
Answer the question.
Answer only the question. Let's do an exercise. Do you know what color the sky is right now? Most of you probably answered blue. If so, wrong answer. Try again. Do you know what color the sky is right now? Hint, this is a yes or no question. If I want to know what color you think the sky is, I will ask you a follow-up question. What color is the sky? And be ready to back up your answer. When did you last see the sky? Isn't it true that there were some clouds in the sky today? If it was blue 5 hours ago, how do you still know it's blue right now? Couldn't the weather have changed? Most people answer blue, even if the sky is gray or it's the middle of the night. Think about your answer before you give it.
We practice this at the empowerment classes and webinars. So if you hear watch your tone, it means you're talking in an ugly tone.
Or you are being angry.
Or you are being whiny.
Or indignant. No apologies, no excuses. We practice tough love here. Fix the tone and be a winner.
The Eviction Defense Network has a 98% success rate in resolving eviction cases. While there is no guarantee, our success rate speaks volumes about our experience, knowledge, and commitment. Through our empowerment classes, we are teaching people to represent themselves with a 99% success rate, but only if you follow instructions. Watch the videos, come to the empowerment classes, do what we ask you to do. Invest the time it takes to get the knowledge and skills to succeed. I went to law school for 4 years and didn't learn how to do a trial. We're trying to teach you how to learn how to do a trial through these classes. So you really have to invest the time. People often ask, how often do I have to come? You don't have to come at all. You should come as often as you can. You will learn something new every time. You will absorb not only information, but a feeling of confidence. And we are having huge success with people who are doing this. Don't be like our client who is smart and educated and organized and busy and thought she could cut corners and come sometimes and be in and out of the classes. In the end, she had not absorbed enough of that winning spirit or enough of the skills because she had not practiced them consistently. After a day of jury selection where we were guiding her by text, she felt like she had to take a deal to move. We guided her through the negotiation via text to a decent deal, but she did give up a below market rate apartment. That probably would not have happened if she had been a better tenant empowerment program participant. Join us on Monday and Wednesday at 5:30 and Saturday at 8:30 a.m.
Our community is a ship in a storm. We are taking on water, and all our lawyers are in the water rescuing others.
We can only give a lawyer to 10% of the people who need lawyers. That means that 9 out of 10 of you need to learn to swim.
Help us bail out the water by educating yourselves. These empowerment classes and webinars will give you the knowledge and skills you need to survive until a lawyer frees up or until you are strong enough to represent yourself.
We're available to you 6 days a week.
Help us be efficient at the empowerment classes and webinars by watching How to Get Legal Help on the front page of our website.
And by reviewing From Zoom to Victory regularly.
Know how to rename yourself.
And have a current, up-to-date PIP ready to post in the chat when asked to do so.
We are fighting for a better tomorrow.
A future where there will be enough lawyers for everyone.
In the meantime, we are recruiting hundreds of tenants that have gone through the process successfully and are willing to help others. We are also recruiting organizers, teachers, the faith community, labor unions, and the staff of social and service organizations.
Remember that the office, the EDN office, is overloaded. Use your main email string, always reply all. But if we don't get back to you, you need to come to an empowerment class or a webinar to get an update.
If you are confused or need emotional or moral support, please come to a tenant support group meeting.
We are here in the video series.
Be a winner. Attend our empowerment classes and webinars regularly. Together, we can all be winners.
Arrive on time.
Mute and rename yourself as soon as you join.
Watch our videos over and over and take notes. It takes multiple times to absorb the information.
Come prepared with your current PIP, and when asked, be ready to put it privately to the host in the chat.
Come prepared with your trial notebook and exhibit notebook. The trial notebook is all of your court papers. Your exhibit notebook has your proof. Watch the videos on how to put those together.
Memorize your case number. Know your landlord's name and the name of the opposing counsel and the court department number. We will not waste time listening to you shuffle through papers to find this information.
Listen carefully when we're answering questions from other tenants. You never know when another tenant will ask what you were going to ask. And if they do, please don't ask the same question. You also never know when another tenant will ask something you wish you had thought to ask.
Be respectful of the attorneys, our staff, our volunteers, and all the other tenants.
Practice your late night FM DJ voice.
Practice your poker face.
And memorize, yes, memorize the ship in the storm speech, because together we can all be winners.
We look forward to meeting you at the empowerment classes and webinars. And remember,
When we fight,
we win.
end recording.